Okay, we are now beginning your course. This is week 1 of, it's titled Workers' Compensation. So this course is Workers' Compensation, Social Security, and Bankruptcy Law. Not really sure why all of them are bunched together like that, but they are. So we're actually going to go in opposite order. We're going to start with bankruptcy. Now, the book you're going to use for this is The ABCs of Debt. I am using the 4th edition. If you're using a different edition, that's fine. This is a pretty intense book. If you don't have time during this course to read the entire book, I would still keep it because bankruptcy law is an area of law that utilizes paralegals a great deal. With bankruptcy law, there's an awful lot of information that has to be amassed, and that takes time and energy. And the attorney doesn't make money unless there are new cases coming in all the time, and the attorney can't spend the time it takes to properly put together the file, getting medical records, doctors reports, everything that you need to put together for certain kinds of bankruptcies where you're saying you have a medical issue. Also, lots of billing statements that have to be put together, calling creditors. So there's an awful lot of behind the scenes work that goes into preparing a bankruptcy file. Also, a lot of lawyers who are in domestic relations, doing divorces, end up also doing bankruptcy work. That was what I did. I did a lot of domestic relations work. Most of my clients ended up filing for bankruptcy because you had 2 incomes supporting one household. You split it up, you've got half of the money supporting 2 incomes or 2 households. So in many divorces, bankruptcy is the best option. I actually had a paralegal in my office, and I paid her per bankruptcy. When she got the file together, gave her a lump sum, and it encouraged her to get them done quickly. A lot of law offices do that. So understand that the reason I'm going to really focus on bankruptcy law, and the reason why I want you to keep this book, is you can make money at it. But you have to understand not just bankruptcy law, you have to understand kind of finance and credit law. And that's what we're going to be spending some time on before we even get to how to file for a bankruptcy. I'm not going to do every chapter in the book. I'm going to hit the highlights because we still have to do Social Security and workers' comp. I'm going to tell you workers' comp is 1 lecture. There's not a whole lot to it. Social Security will be 2 lectures. So, doing the math, we're going to do 11 to 12 weeks of bankruptcy. Why do I say 11 to 12? Because you're going to have a final exam at the end, and actually it's not a final. It'll be you have 3 tests in this class. 1 will be over bankruptcy, 1 will be over workers' comp, and 1 will be over Social Security law. Okay, so let's get started. I'm going to start on chapter 2, which is called Secured and Unsecured Debt. Okay, we have to understand how debt is amassed because that's the basis of filing for bankruptcy. What kind of debt do you have? That's a really big part of putting together a bankruptcy petition. There are different kinds of debt. There's voluntary, there's involuntary, there's secured, there's unsecured. There's some that are created by judgments. There are some that are created by law if you don't pay your taxes or your child support. And each category of debt is treated differently. So we're going to start large and then work down to specifics. We're going to start with secured versus unsecured debt. Okay? Secured debt is where you have promised some kind of collateral, something of value in exchange for a creditor giving you credit. Okay, so when I buy a car, I really don't own that car if I financed it. I own a car that if I don't make my payments, my creditor is going to come and take my collateral, my car. That's what a secured debt is, where something of value secures or makes the creditor feel secure about giving you the money, extending the credit. Okay? So when you go into debt with a secured debt, you are using some kind of property to secure it. That's called collateral. Okay? Now, there are lots of different ways to have a security interest. One is where you where you sign what's called a security document. This is where you create a security interest for the creditor in whatever it is you're giving the creditor as collateral. Okay? Usually there is a document called an installment sale and security agreement, where you say, I will make installment payments to you, creditor, and if I fail, if I don't make those payments on time, or I don't make them fully and on time, you then can execute your security agreement. You can come and take the collateral. When you buy a car and you finance it, this is the agreement that you sign. Okay? Most people, when they go and sign a finance agreement, I'm always amazed. I don't know what I signed. They just handed me a stack of papers. Really, really, really important that you read this installment sale and security agreement. It will have in it the terms and conditions under which you can actually lose your collateral. For instance, a lot of security agreements say that they will give you a grace period of up to 5 days past the date that your payment is due. And after that, they don't have to accept any money from you. So let's say I buy a car and I finance it, and I pay on the 6th day. My security agreement says you can have 5 days. 5 days grace period. But if we don't receive it by then, sorry, we're coming to take the car. So what if on day 6 I try to give the payment to the creditor? The creditor will say, sorry, I'm not going to take it. You can either, Diane, you can either pay the entire amount that you owe us with interest, or that's it. That's what our agreement says. And most security agreements, installment and sale security agreements, have that provision in it, where the creditor doesn't have to work with you. Doesn't have to say, okay, it's day 6, here go, I'll go ahead and take the payment. They don't have to. And if they start making the precedent of taking it on day 6, guarantee you, next month it'll be on day 7. It's just one more day. Same thing if I make a partial payment. Let's say that before day 5 or on the day due, I make half the payment. Creditor's going to say, no, I'll take half of it, but you better have the rest of it before that 5-day grace period's over. Or we stop our agreement. You can either pay me the entire dollar amount in one lump sum, or you can give us the car. That's simple. Okay? These installment sale and security agreements are important, and you have to know the terms. You must know the terms and conditions. Okay? Once you sign one of these agreements, the creditor is going to take that agreement and take it to the recorder's office in the county where you did the transaction. Why? Well, the recorder's office, the purpose of the recorder's office is to let the world know, hey, I have a security interest in this personal property, this car. A security interest is also called a lien, L-I-E-N. I have a lien on this vehicle, on this personal property. Why is that important? Well, what if I decided I needed some cash and I've already financed the car, but I go to someone and I say, hey, can you loan me some money? I'll use the car as collateral. What that person, the second creditor, is going to do is go to the recorder's office to make sure there are no liens on the car. That's important because when it comes to liens, whoever files the security agreement with the recorder's office first wins. So if I don't make payments to creditor number one can take my car, the entire thing, right away. Creditor number two, who thinks that they have collateral, my car, lien on my car, is out of luck. So the county recorder's office is a way for people who loan money and are going to use collateral to make sure that there are no other creditors out there with liens or security agreements using that same personal property, the car, as collateral. Right? I don't want to be number 2 or number 3 in the line. I want to be number 1. And if there is already a number 1, I'm not going to loan you money. At least not using that personal property as collateral. Okay? That's called perfection of the lien. Okay? If I file my security agreement with the county recorder's office, I have perfected my lien. And any other creditors out there who want to use the same personal property that is in my security agreement, they're out of luck. Okay? So there are a lot of cases in this chapter. You don't have to read them. I'm not going to require you to. But again, if you have a moment, they're good to give you perspective on how these liens are interpreted by courts. Okay, a mortgage is a very specific kind of security agreement that is consensually entered into by contract. It is a contract, a security agreement for real property. Now, the reason why we do this, why we have a whole separate category for real property, is that we have constitutional due process issues that only apply to real property. Real property is something that the ability to own real property is a right that's secured by the Constitution. And so we have to make sure that creditors that use real property as collateral follow certain rules. And if you're the debtor that has to make the installment payments to pay off the creditor for the real property, that you're fully aware that what you're doing is basically playing with fire. Okay? A security interest, a secured debt, where you take personal property and you pledge it to the creditor, is one thing, if it's personal property. Real property, a little bit different, right? Because, again, it is constitutionally protected. So your book has a sample mortgage agreement in there. And just like we talked about with the vehicle, one really big thing that people do not understand, that debtors do not understand when it comes to a mortgage, a special kind of secured debt, is just like with your personal property. If you do not make your payments on time, if you don't make your installment payments on time and fully, and you miss one payment by one day, the contract's over. The creditor will come and say, I'm sorry, I'm not going to even accept a late payment. You can pay me the full mortgage amount with interest and attorney's fees and court costs. Or we're going to do what's called a foreclosure. We are going to institute a lawsuit so that the court will determine that you've been given all of your due process, and then we will be able to seize the collateral. It's terrible. Okay? We do add in this one extra step of a court hearing so that you have the opportunity to say, look, I didn't get due process, or look, I did make the payment, here are the receipts. There are mistakes that happen, especially because in the last 10 years, the banking industry has changed so dramatically, where I may have had my mortgage I may have signed the secured agreement and went into the mortgage with a small local bank, which has now been gobbled up by a gigantic bank, which then sold my mortgage to another party. So there's lots and lots of moving parts. And so what we do is we make sure that there wasn't a mistake, that there wasn't a misunderstanding. And the court protects the individual's due process rights to make sure that, in fact, you just missed your payment. And if you did just miss your payment, you're done. And the court will say, I'm really sorry, but unless you can pay the full purchase price, plus the attorney's fees that are associated with the foreclosure, plus interest, the court is going to grant the mortgage holder, the creditor, the bank, the ability to take possession of the property, either a residence or a commercial piece of property. It won't belong to you. Now, a lot of people say, I bought a house, it's great. No, you didn't buy a house. You're moving into a house that the bank or the mortgage holder owns. What they're doing is they are splitting the interest in that piece of property. There's the equitable interest and the legal interest. The equitable interest is you can use the property as long as you are meeting the terms and conditions of this mortgage agreement, which again, remember, is a security agreement. As long as you're making your payments on time, you can enjoy living there. And then when you've fulfilled the contractual obligations, you've paid us in full, we will then transfer legal title to you. So both of those go together. But I'm always leery. My daughter just bought a house. We bought a house. No, you live in a house that the bank owns. Make your payments. Don't miss one. Don't be late. Okay? Because they have a secured interest. Just like the example with the car, the bank or whoever loans the money, the creditor that loans the money to finance the house, will perfect their security interest in the county recorder's office. Again, if I want to take a second mortgage out to do repairs, whoever it is who I'm going to get money and wants to take a security interest in my home is going to go to the county recorder's office to see Who is the first lien holder? How much money is there? Okay? Lots of times, you will pay down your house. Let's say your house is worth $100,000. You put $20,000 of your own money down and you borrowed $80,000. And after 5 years, you've paid it down, and maybe now you only owe $70,000 on the house. Now, hopefully you've paid off more than that. So let's say it's $50,000. Okay? After 5 years, you owe $50,000. That means that you own $50,000 worth of the value of the house, and your creditor, the bank, owns $50,000. That $50,000 that you've paid off is called your equity interest. You own 50% of the house because you've paid off your creditor to a certain amount, and you've put your own money into the pot. So you own $50,000 of a house that's valued at $100,000. You can use that equity to go to another lender and say, I own $50,000 worth of a $100,000 house. I want to borrow $10,000. You can take a $10,000 security interest in this home. Okay, that's what we mean when we say someone took a second mortgage or an equity loan, home equity loan. That's what it means. You're borrowing against the value that you own of that property. And again, whoever that second mortgage company is, whoever you're going to borrow money against your equity interest, is going to go to the recorder's office, see how much the value of the house is, see whether they think the house is worth $100,000, and see whether they think they're protected, because if the first mortgage holder forecloses, they get $50,000. Is there going to be enough money left for them to get their $10,000? Okay? That's how it works. Okay? Now, your book goes through predatory lending to consumer debtors. Look, nobody makes somebody. I've never seen someone go down the street, grab someone by the ear, bring them in, and say, you will sign this loan. Nobody makes you or force you to do anything. You may think that you have no other options, but nobody's making you enter into a contractual arrangement. Nobody's making you sign a loan. Okay? It is important to understand that. So while there are people out there who are, saying, well, we'll give you the best deal in town. We'll let you borrow up to $100,000 of your value of your home. They are appealing to not your greatest interests. They don't have your greatest interests at heart. But at the same time, you're a thinking human being who can read. Read it. Read it. Don't make silly financial decisions. And don't make financial decisions that are based on emotions. It's money. It is transactional. There are a lot of things that you'll say, I've always wanted, or, but if you're borrowing money at 23% interest, which is what credit cards are right now, you really have to step back and make a financial decision that's based on facts and not based on emotions. Okay? So those are two big kinds of secured debts. But you can have other kinds of secured debts. When we have credit cards, most credit cards are unsecured, meaning there's no collateral. Means if I don't pay MasterCard, they have to take me to court to get their money. It's not like they can come and take the blender that I bought with the MasterCard. It doesn't work that way. However, there are certain credit cards that are secured. For instance, if you're doing a home improvement, let's say you're putting carpeting in your house or hardwood floors in your house, and you go to Lowe's. Lowe's will issue you a special credit card. But I already have a Lowe's credit card. But I'm going to give you a secured Lowe's credit card. So what does that mean? That means that if I don't make the installment payments on my flooring, Lowe's is going to come take my flooring. And if you think that that's never going to happen, let me just tell you, I've seen it. Sears used to be the biggest secured credit card company, at least that I knew of. And people would get their windows with Sears, or their carpeting, or their refrigerators from Sears. And they would have you sign an installment loan security agreement. But they'd give you a credit card. So you think you were just putting it on the credit card. But if you don't make your timely payments on that credit card, Sears would come, I've seen it, and take carpeting out of your house. I've seen it where Sears would come and take windows out of your house. They did it. Now, who wants that to happen? It was great leverage on the part of Sears, and now Lowe's or Home Depot or whoever you go to make sure you make your payments. Because otherwise they will call you and say, okay, well, we'll be there next Tuesday to take the windows out. And they did it. So make sure, if you're doing a home improvement, and that whoever it is you're going to, whichever big box store you're going to, or if you're buying an appliance, a lot of these, Best Buy, I know Best Buy, when they sell an appliance and they finance it, they have you sign a security agreement. They go perfect that security agreement by filing it at the county recorder's office. And if you don't make your payments on that refrigerator or that stove or that dishwasher, Best Buy will come and take it back. That's how it works. Those are secured transactions. We treat them differently in bankruptcy than we treat unsecured transactions. And you will see when we do a bankruptcy petition that there's a specific section that's set apart for doing listing secured debts and listing unsecured debts. Okay? So that's our first distinction when it comes to debt. Secured versus unsecured. It's the first question you ask. Is it a secured or unsecured agreement? What's the collateral? It's the first step in putting together a bankruptcy petition. Okay? I'm going to give you some vocabulary and some questions to answer for your questions for this module. And then I'm also going to give you a discussion question on bankruptcy and predatory lenders. Okay? So make sure you get those done. And then we will begin on non-consensual liens in the next chapter. If you have any questions, please feel free to contact me.